We Hold These Truths, a reverent review of the U.S. Constitution by Lawrence Patton McDonald. Chapter 12, The Law of the Land. During the first century of American government under the Constitution, changes in the meaning of the Constitution by the Supreme Court resulted essentially from economic forces. Supreme Court justices, perhaps not fully comprehending the import of what they were doing, were reading new meanings into the Constitution so that Congress and the President could make such arrangements of the economic activities of the nation as the President and Congress thought necessary and proper. Even during the early 1880s, when the Supreme Court began transforming the due process and equal protection clauses of the 14th Amendment into an unlimited, undefinable grant of new power for Congress and of the President, and for a long time after that process was complete, the court was responding to the same basic economic motivation. Witness the fact, discussed previously in Chapter 7 of this book, that for more than 40 years after the court began interpreting the 14th Amendment as a source of federal power over states and the people, very few Supreme Court cases involved the social problem which it was the allegedly exclusive intent of the 14th Amendment to solve, that is, the relationship between blacks and whites. Until well into the 1920s, an overwhelming majority of all Supreme Court decisions under the 14th Amendment dealt with economic problems. They had nothing to do with blacks as such or with any social problem. The 14th Amendment had been aimed at Southern states, but it was worded so that it applied to all states. Apparently, the creators of the 14th Amendment assumed that states outside the South did not have a social problem involving the black-white relationship. That relationship, however, has been a tragic problem throughout America since Dutch, English, New England, and New York merchants first started buying blacks, often from other blacks, in Africa and selling them to white Southern planters in America. Economic profits from the slave trade were divided first between blacks who sold slaves in Africa and between white merchants in the North and white planters in the South. But most of the social problems it caused were heavily concentrated in the South because that is where most of the hapless blacks went and stayed. 200 years of slavery created relationships that would have been slow to change for the better under the best of circumstances. Blacks were freed under the worst of circumstances suddenly by a storm of violence, and they were started unprepared on the long road toward the responsibilities as well as the blessings of freedom amidst a volcano of hatreds which the violence had caused. Conceivably, the road would have been smoother and the trip faster if the freed blacks could have lived amidst the whites who were hailed as their liberators, with no outsiders around to agitate mutual hatreds, resentments, and fears. Unfortunately, it was the other way around. The military power that had destroyed white supremacy in the South established temporary black supremacy. Under the protection of this invading military force, white outsiders manipulated and used Southern blacks but did not educate them or even permit them to learn much about the burdens and responsibilities that freedom itself imposes. When Northern military rule was withdrawn in 1877 and white supremacy was again established in the South, Southern blacks and whites were in even worse condition socially and economically to establish a harmonious society than they would have been if left alone at the end of the Civil War. All these conditions considered, it is a remarkable fact that the first major U.S. Supreme Court decision based on troubled race relations dealt with problems in Massachusetts that existed long before the Civil War. In 1849, a Massachusetts Supreme Court decision held that racial segregation of white and black children in Boston public schools was permissible under the Constitution and laws of Massachusetts, so long as the separate facilities provided for the racially separated children were equal. This case never reached federal courts, but it was the creation, the first court enunciation of the separate but equal facilities doctrine with regard to state handling of race relations. In 1896, Plessy versus Ferguson, the U.S. Supreme Court, acting under authority of the 14th Amendment, reviewed a state law involving racial segregation of passengers on railroads. In Plessy, the court adopted the old Massachusetts separate but equal doctrine. The court upheld the state law in question, saying that racial segregation of railroad passengers is permissible under the 14th Amendment so long as the separated facilities are equal. This was the first major case in which the U.S. Supreme Court decided that the 14th Amendment empowers the federal government to set and enforce national standards for state handling of sociological problems as distinguished from economic problems. That is significant. Sociology embraces not only economics, politics, and religion, but every other aspect of human existence, from sex to sowing wheat. It can cover mental attitudes, social mores and behavior, education, delicate relationships between men and women, and between adults and children, crime and punishment, work and play, everything involving human life from before it begins until after it ends. In a huge and varied society like ours, problems that are now called sociological are infinite in kind, intensity, and number. And they are constantly changing from state to state, from region to region, and from time to time. Any governmental controls necessary for the handling of such problems should never be imposed by any political power further away than the state line. That is why the framers of the Constitution were careful to preserve state sovereignty in the handling of all such matters. Adhering to that principle and obeying the constitutional provisions which enforced it become more important as our society becomes bigger and more complex. A national sociological standard set by the government cannot really fit any community because it is tailored for a non-existent general average. The 1896 Supreme Court's Plessy case did far more than improve an old Massachusetts separate but equal doctrine as a national standard for all states to follow. It upheld the state ruling true. But at the same time, it made the federal Supreme Court the final arbiter. It created an opening through which subsequent court decisions could expand new federal powers until the federal government would have enough illicit power to dictate and control every aspect of human life in the United States. After 1896, courts kept ceding the federal government more power, but none of them, not even the New Deal Court, really capitalized on the awful powers of the new 14th Amendment as unveiled in Plessy. The New Deal Court ended in 1953 when Eisenhower paid off a political debt by appointing the former governor of California, Earl Warren, as Chief Justice. The Warren Court reign lasted until June 9th of 1969, when Warren was succeeded in the Chief Justiceship by Warren Earl Burger. The Warren Court initiated and the Burger Court continued a new epoch in American history. In May 1954, Brown versus School Board, the Warren Court by unanimous vote overturned a Kansas state law under which school boards at Topeka and elsewhere were operating racially segregated public schools, providing separate but equal facilities for each racial group in conformity with the separate but equal doctrine. The Warren Court said it had concluded from looking into books and statements by sociologists and psychologists that segregating black children from white children in public schools is bad for the blacks, no matter what kind of facilities are provided, and no matter what the 14th Amendment or any other part of the Constitution provides. The Warren Court claimed authority under the 14th Amendment to hear and decide the Brown case, but acknowledged that the amendment was not intended to affect the operation of public schools. All previous Supreme Court changes of the Constitution had been twistings to make it yield authority for the President and Congress to do anything that met with Supreme Court approval. In the Brown case, the court arrogated unto itself authority that was superior not only to that of Congress and the President, but also to that of the Constitution itself, as expanded and developed by later court decisions, as followed by lower courts, both federal and state, and as enforced by federal legislative and executive power. The 1954 Brown decision means that the Supreme Court has the power to order any person or group of persons anywhere in the United States to do anything a majority of the court justices might at the moment think is the sociologically correct thing to be done. It has this power no matter what the Constitution says or the people, including the members of Congress and the President, might want. The Supreme Court may reverse its own far-reaching decisions at any time because its decisions are not based on the Constitution but on books and other influences operating upon the justices. That is the inevitable consequence of the Warren Court's revolutionary 1954 decision. There were only two remaining restraints upon Supreme Court power. Number one, it could not issue an order about anything unless a case was brought before it. And number two, it could not enforce its own orders because doing that was in the hands of the executive and legislative branches. There were in 1954 many well-financed tax-exempt cause agitating groups available to file lawsuits that would bring before the Supreme Court cases affecting not only race relations, but many other sociological problems. Within a few years, there was hardly a sociological problem of any kind that had not been seized upon by activist organizations hiring activist lawyers to bring such problems before the Supreme Court. Please understand, a Supreme Court decision is not the law of the land. Indeed, it is not a law at all. Only legislatures can make laws. A Supreme Court decision is a rule that is binding only on the parties involved in the case, and it is enforceable only on that limited group if the executive and legislative branches choose to enforce it. However, when a Supreme Court decision overrules a few people in one city of one state, other cities and states generally try to apply the same new standards to whatever they are doing that is similar. In that sense only can a Supreme Court decision be called a law of the land. Most people try to obey it, whether it had anything to do with them or not, because they fear if they do not, in a subsequent case involving them, it will be rammed down their throats anyway. With regard to the 1954 school desegregation decision, not many people outside the South realized what calamities lay ahead if that decision were enforced nationwide as if it were already law. Most politicians, either not caring about future calamities or too obtuse to perceive what is happening, instantly proclaimed the school desegregation decision the supreme law of the land, which we all must obey whether we like it or not. On April 2, 1956, the Warren Court decided the case of Steve Nelson, an admitted Communist Party leader who in 1952 had been given a 20-year prison sentence for violating a state sedition law in Pennsylvania. Nelson's guilt was not a question before the court. only his contention that neither Pennsylvania nor any other state could punish anyone for sedition or related activities because the federal government had preempted that field by the Smith Act of 1940. The Smith Act specifically provides that nothing in this title shall be held to take away or impair the jurisdiction of the courts of the several states. Counsel for the state of Pennsylvania pointed this provision out to the Warren Court and also introduced in evidence a letter from Howard Smith, the member of Congress who had written the Smith Act of 1940. Congressman Smith's letter said that Congress, in passing the Smith Act, never had the faintest notion of nullifying state laws. Warren brushed all this aside, overturned the conviction against the communist leader, and voided all state laws under which communists could be prosecuted. Despite all of the facts to the contrary, the Warren Court ruled that the Smith Act did preempt any state action regarding sedition. In quick succession, other alleged communists brought their cases before Earl Warren. On April 9th of 1956, the Warren Court decided the case of Harry Slowchower, who had been fired from Brooklyn College in New York City. In firing Slowchower, the New York City Board of Higher Education used the administrative due process customary in all such cases. The board told Slowchower he could not teach in a New York tax-supported institution because he had invoked the Fifth Amendment and had refused to answer questions about his alleged associations with communists. Holding a public job is not a constitutional right. Firing other public employees by use of administrative due process is all right. But the national conscience, as determined by the Warren Court, had decided that communists needed special protection because they were a generally disliked minority group. Therefore, before communists could be fired from public jobs, they must be afforded the due process procedures required in federal criminal trials, that is, the presence of counsel, cross-examination of witnesses, and so on. New York City had to reinstate and give back pay to several teachers who had been fired because of their communist activities. Slowchower himself got an indemnity of $40,000 from New York taxpayers. The Warren Court used the same due process rationale to give special protection to many communists who might be persecuted because they belonged to a disliked minority group and applied it in cases involving both state and federal administrative procedures and also in federal criminal trials. In less than 2 years after the Nelson decision of April 2nd, 1956, the Warren Court had made virtually impossible, number one, for government at any level in the United States to prosecute communists for subversive activities. Number two, for government at any level to fire communists from public jobs. Number three, for state governments to keep communist lawyers from becoming members of state bar associations or for bar associations themselves to exclude communists. Number four, for the State Department to refuse passports for communists to travel abroad for high-level communist meetings and then return to the U.S. Or number five, for the federal government to deport communist aliens from the United States. On the other hand, the Warren Court ruled Consul General for Yugoslavia versus Andrew Artukovic that an anti-communist alien who had sought refuge in this country and whose political asylum here had already been upheld by 2 lower federal court decisions must be deported back to communist Yugoslavia. Having decided in the Brown case of 1954 that the Supreme Court can determine what the country should do and then order it done, no matter what the Constitution says, and having determined in a series of 1956 to 1957 communist cases that the Supreme Court may stretch and use due process in any way it pleases in order to give special protection to anyone, for any reason whatever, the Warren Court was ready to plunge into judicial activism. This means that the court decides what the national conscience should be about, protecting any person or group of persons the court wants to protect, and then the court orders affirmative action by all other branches of government at all levels, and ultimately by all semi-private and private organizations, including businesses. And under the misnamed Civil Rights Restoration Act of 1988, probably churches, ministries, and private religious schools as well, to do what the court wants done. The Unconstitutional Civil Rights Act of 1964, broadening and enforcing as law the Warren Court's ukase in the 1954 Brown case, the subsequent Civil Rights Acts and amendments making further expansions, the environmental protection and consumer protection laws, the enormous growth in federal aid for all kinds of activities, all of this has given ample pretext and opportunity for judicial activists in the federal government and elsewhere. As a matter of practice, lower federal courts follow or sometimes outpace the judicial activism of the Supreme Court. For a variety of reasons, many state courts also follow or try to surpass the judicial activism of the Supreme Court. Judicial and bureaucratic activism enforced and supported by vote-hungry politicians who in turn are pushed by a host of power-hungry and mostly tax-exempt special interest organizations has turned this country upside down and inside out. The conscience of the nation, as determined by the Supreme Court, has given special due process protection to common criminals, prison inmates, hospital patients dissatisfied with the care they get, sexual perverts who feel they are being discriminated against because of what they are, and many others. Atheists have been given such special protection so that a half dozen of them can, through the federal courts, impose their will upon millions of other citizens. Using the First Amendment as its authority, which prohibits the federal government from interfering with the free exercise of religion, the Warren Court prohibited public school children from free religious exercises that seemed objectionable only to a tiny minority of atheists. Universities have dropped academic standards and have established quotas for hiring unfit teachers and admitting unfit students in order not to be found guilty of discrimination because of race, color, creed, sex, or what not. Private and public employers have similarly been forced to lower or abandon employment standards in order to hire and promote members of protected groups without regard to qualifications. But loyal and qualified employees who were thus kept out of jobs or promotions they deserve had no such special protection until a 1989 Supreme Court decision. Destructive mobs demonstrating for black rights in southern states, in the guise of peaceful civil disobedience but under the leadership of professional agitators of hate and violence, were excused by the Supreme Court for violating state laws against criminal trespass, vandalism, and obscene behavior in public. Overturning state convictions against civil rights demonstrators for committing such crimes in southern states, the Supreme Court has said the demonstrators were merely exercising their right of free speech, and that the more their free speech hurts, the more good it will do. On the other hand, gatherings of angry parents, students, and taxpayers protesting Supreme Court orders designed to shatter not only their school systems but their whole social order are not exercising their right to free speech. They must be swept aside at the point of Army bayonets if necessary, as at Little Rock, Arkansas in 1957 and again in Oxford, Mississippi in 1962. In 1970, the Burger Court extended the Warren Court's due process rationale to cover welfare recipients. They cannot be stopped from illegally getting welfare they are not entitled to under the law without the full rigmarole of due process of law. This rule also protects tenants in public housing. It was until early 1989 almost impossible for public housing authorities to expel hoodlums, narcotics pushers, agitators, or anyone else from a public housing unit. The 1970 ruling has been extended to give special due process protection to students in public schools and colleges. It is now impossible to expel political activists and common criminals from public educational institutions or otherwise discipline them if some lawyer or agitation group gets hold of them and demands that they be given the full due process of law treatment that federal courts prescribe. The 1970 Burger Court ruling has been stretched to give the special federal due process protection to drunks and others threatened with revocation of driving licenses and to unwed fathers seeking custody of their children. Activist state and federal judges and activist federal bureaucrats now assume authority to select routes for highways, sites for power plants, locations for apartment buildings and shopping centers. Federal judges establish smoking or no smoking rules in public places, establish rules for the playing of intercollegiate football games, pass upon the validity of contracts between professional athletes and team owners. The Pennsylvania Supreme Court even ruled that a judge may settle a dispute that involved a man's relationship with his church and his sexual relationship with his wife. The Burger Court presumed to decide when life begins in a woman's womb and at what period in the process of gestation abortion may not be considered the taking of a human life. In Richmond, Virginia, one federal judge said he found sexual and racial discrimination in the employment practices of the American Tobacco Company, ordering the company to promote females and blacks to jobs the judge wanted them to have was not enough to satisfy the judge. However, that would have been too slow because the American Tobacco Company has a very low employee turnover rate. The federal judge therefore declared certain jobs to be vacant at 3 different American Tobacco Company locations. He ordered the company to let female or black employees pick any jobs they wanted. Any employee bumped out of a job by the judge's order could pick another job he wants at no less of pay. Federal judges have assumed power to act as administrators of prisons, hospitals, school systems, and private businesses. They have invalidated a constitutional amendment on housing that was adopted by a majority of voters of California. They have vacated seats on school boards and filled them with their own selection. They have closed schools and they have forced other districts to build new ones. They have canceled school elections and set school tax rates. They have prohibited press coverage of trials. In the Civil Rights Act of 1964, which the federal courts and the old Department of Health, Education, and Welfare pretended to be enforcing with their school busing orders, Congress ordered public school desegregation, which is defined as meaning the assignment of students to public schools and within such schools without regard to their race, color, religion, or national origin. The Act specifically says that desegregation shall not mean assignment of students in order to overcome racial imbalance. And it declares that nothing in the Act shall empower any official or court of the United States to issue any order seeking to achieve a racial balance in any school by requiring the transportation of pupils such racial balance. Northern schools complied with the act by adopting freedom of choice plans, allowing every student of whatever race freedom to attend the public school of his choice. Federal courts and bureaucrats at first approved that system in the North, having tried other means to delay or avoid the costly disaster of immediate change in their school systems. Southern states adopted the freedom of choice plans which had been approved for the North. Neither HEW nor the federal courts would permit the South to operate under freedom of choice plans because not enough students were choosing the way Washington wished. Before long, Northern freedom of choice was also objectionable to the Washington fixers of the nation's conscience and the Washington dispensers of the nation's tax money. So, the school busing madness, which started in the South, spread to most other parts of the nation. The court and HEW officials acting in violation of the Civil Rights Act they were supported to be enforcing, and in violation of provisions which Congress has inserted in numerous appropriations bills, set racial quotas. Something of a climax was reached in Boston in December 1975 when a federal judge took over a school system and started operating like a one-man school board through his own appointees, making taxpayers find the money for his preposterous decisions. HEW controlled private colleges that did not take federal aid because students going to those colleges get scholarship grants or other aid from the federal government. Two cases in point are Hillsdale College in Michigan and Brigham Young University in Utah. The Department of Health, Education, and Welfare cited both schools for violating the Education Amendment Acts of 1972, which outlaw sex discrimination in an institution receiving federal tax money in any way. HEW bureaucrats said it was illegal for the colleges to have separate curfew times for men and women, to have rules about pregnant teachers, or to have sports programs and dress codes that do not treat women and men as if they were exactly alike. Brigham Young officials said the HEW regulations would interfere with religious and moral beliefs, that differences in dress and grooming of men and women are proper expressions of God-given differences in the sexes. The president of Hillsdale College, George C. Roche III, promised to resist the HEW edict, saying, "None of us at Hillsdale underestimates the power of the federal government to harass and possibly destroy those who do not comply, but we feel the fight must be made if independent education is to endure in America." When federal Department of Education bureaucrats used the pretense that a school which accepts students who pay their tuition with money from the GI Bill is thereby accepting federal aid to try to coerce Grove City College into following all manner of bureaucratic guidelines, a legal battle ensued. The college, which has never discriminated upon the basis of race or accepted civil government aid of any kind, resisted the federal government's attempt to take control of the college via making it submit to bureaucratic regulations. When the court battle resulted in a partial victory for the college, Congress, under pressure from civil rights groups and the homosexual lobby, passed the Unconstitutional Civil Rights Restoration Act of 1988. Though many of those who voted for this act deny it, the language of the law opens the way to establishing homosexuality as a constitutionally protected activity, to requiring religious schools and organizations which consider sodomy to be a vile sin to hire homosexuals, and to further incursions upon freedom of religion. Since the mid-1970s, the Supreme Court, laboring under its extra-constitutional doctrine of a wall of separation between church and state, has banned the Ten Commandments from the public schools, prohibited even silent prayer in the public schools, left the door open for public school bureaucrats to discriminate against religious students by forbidding religious students to meet together as clubs on campus, forbidding public school students to pass out religious materials before or after school, and secularizing public school Christmas programs. It has also prevented the teaching of creation science theory while mandating the exclusive teaching of the secularist dogma of evolutionism in the public school. In addition, in the Bob Jones University case, the Supreme Court declared that the Internal Revenue Service has a right to revoke the tax-exempt status of a private religious university because that institution's interpretation of the Bible as prohibiting interracial dating and marriage was contrary to settled public policy, not because the school's practice violated the Constitution, which it did not. Furthermore, undefined terms such as compelling state interest and unclear tests and guidelines invented by the court but not rooted in the Constitution have combined with the extra-constitutional, secularist, absolute separation dogma of the court to produce inconsistencies and opportunities for lower federal courts and local government officials to arbitrarily further restrict individual liberty and the free exercise of religion. Under the impact of such rulings, local governments have been forced to remove religious symbols from their official seals, regardless of how important a part religion has been in their heritage. Moreover, preachers have been arrested for preaching the gospel in the streets. Churches, church ministries, schools, or daycare centers have been shut down, and ministers arrested for refusing to comply with state or local bureaucratic licensing requirements. County or local zoning boards have refused to permit churches or Christian schools to be established on privately owned property. Churches have been deprived of the use of public parks for Easter services, and some local zoning boards have even prohibited individuals from holding Bible studies in their own homes. There is no way to estimate what all of this has cost the country. How many billions of dollars has it cost to redraw school district lines, tear down and put up school buildings, buy tens of thousands of buses, and haul children miles from home instead of letting them walk to neighborhood schools? But far more than money has been lost. There is no way to tell how much violence and soul-shattering disorder has been caused. Nor is there any way to tell how much intellectual, moral, and physical disorder has been and is being caused by the federal court's rejection of our traditional understanding of the First Amendment's principles regarding the relationship between religion, education, and the state, an understanding which never sought to de-Christianize, much less secularize American education or civil government. All of this ghastly disruption cannot, however, be blamed exclusively on the courts and the HEW and later Department of Education, bureaucrats, or on the Congresses and presidents who enacted the Unconstitutional Civil Rights Act and the Unconstitutional Civil Rights Restoration Act. In the final analysis, the blame rests on the people who advocated federal aid to education as well as on radical or confused federal courts because they wanted Washington to help pay for their local schools. Without such federal aid, we would never have had the federally enforced busing, the general federalizing of our public school systems, the consequent opportunity for secularist educational theorists to launch destructive federal educational experiments against American education, and the open door for radical Supreme Court majorities to project federal power into local jurisdictions, our local schools, and even private religious institutions. The Supreme Court ruling in mid-1989 that the First Amendment allowed free expression, a term which is not in the Constitution, through burning of the United States flag as a protest was another example of the continued destruction of our Constitution, state sovereignty, and common sense.